filings with the Massachusetts Disclosure Commission as late as January 2003, Mitt Romney is describing himself as an executive of Bain Capital, and then all of a sudden, and this coincides with his political ambitions and pursuits, he tells the federal government in a financial disclosure form that he, in fact, wasn't involved with Bain after February of 1999, directly contradicting the certified record before the Securities and Exchange Commission.
That was Obama campaign attorney Bob Bauer on a conference call today asking how Mitt Romney can tell the federal government he wasn't involved with Bain after 1999 on one form, and when a Bain document shows that he was still the CEO on another form. Obama Deputy Campaign Manager Stephanie Cutter went even further, asking if this could amount to a felony.
Either Mitt Romney, through his own words and his own signature, was misrepresenting his position at Bain to the SEC, which is a felony, or he was misrepresenting his position at Bain to the American people to avoid responsibility for some of the consequences of his investments. And if that's the case, if he was lying to the American people, then that's a real character and trust issue.
Joining us now is Roberta Carmel, a former commissioner of the Securities and Exchange Commission and is currently the Centennial Professor of Law at Brooklyn Law School. Professor, you're also mentioned in the Boston Globe article analyzing these SEC filings. And we have one right up on the board here behind you that you've seen already, indicating that Mitt Romney is the chief executive officer, he's the president, he's the managing director, long after Mitt Romney has claimed he was none of those things.
Right, and I believe it says that was his principal occupation.
Yes. What are we to make of this? Is this something that the SEC takes casually?
No. Documents like this that are filed with the SEC are serious documents, and if information in those documents is false or misleading, there are serious consequences. There can be civil cases brought by the SEC, and depending on the facts and circumstances, if there's a false filing with the SEC, there can even be a criminal prosecution. I'm not saying Mitt Romney should be criminally prosecuted, but that is a possible consequence of a false filing of a document like this with the SEC.
Bain Capital is making a big deal about what they call, in their statement today, their short statement, the sudden nature of Mr. Romney's departure. There are sudden departures all the time in business. People get fired. People die. Do they not change the SEC filings after sudden departures? Is that common?
Well, if there is a filing by a company, for example, that shows that Mr. X is the president, CEO, chairman of the board, and Mr. X is fired or dies, that company has to make a filing to correct the former filing. Is
there some kind of memo they could have issued saying, look, this just happened, we are working this out, he's technically still on these forms? Is there some intermediate filing they could have made?
Not a memo, but what you do is if there's a material change from a form that was filed before, you have to make a new filing.
So when you are attesting, as Mitt Romney did, that you are the CEO, the managing director, you're essentially signing up for some sort of responsibility and accountability. I mean, what does it actually mean to put that attestation on a statement from the SEC's perspective?
Well, this document is not a document. This document is a document of a portfolio company, and had to do with whether or not Mitt Romney was a controlling person of that portfolio company. And his position at Bain Capital. And generally, when a businessman is the chairman, CEO, and in this case, a sole stockholder, he's accountable for the business and affairs of that company. And even if he's not making day-to-day decisions or managing the investments of a company like this, which was a venture capital company, he's still legally responsible and should be accountable for the business and affairs of that company. Unfortunately, too many business executives have tried to exculpate themselves from that kind of accountability, and it's one reason that in 2002 Congress passed the Sarbanes-Oxley Act, compelling CEOs of public companies to certify financial statements. That wouldn't.
Yeah, Roberta, hello down there.
Sorry.
I wanted to ask you maybe to play referee here a little bit, because there's an article in Fortune that came out this afternoon that the Romney campaign and his defenders are really pointing to, and they're saying it sort of exonerates him from the suggestion that he had day-to-day involvement. And because I'm not good with the terms, I'm going to read from here to make sure I get this right. But what they're saying they have found are offering documents for a Bain Capital fund from 2000 and from 2001, and they show that in these documents Mitt Romney is not listed as, quote, a key investment professional, and that this establishes that there was not operational input on Romney's part in terms of Bain's activities, even if there was a legal and financial relationship still in place. Do you think there's anything to that explanation?
Well, somebody who's running a venture capital company may not be making day-to-day decisions as to what portfolio investments that company is going to make.
Especially if the company has a lot of them.
Yes.
Those are delegated frequently.
But at least in my experience, it would be unusual for somebody who is the 100% owner of a company like that and is still holding the positions of CEO, chairman of the board, not to pay attention to what kind of investments are being made by the company and not to monitor those investments.
Cal, what do you make of the revelations that Fortune thinks they've come up with today?
Well, they make some good points. I think that it's important to note that, as Roberta pointed out, there's nobody really suggesting that Mitt Romney had his hands in every single day-to-day operation at Bain Capital. We know that he had his hands full out in Utah running the Olympics. But the fact of the matter is that the documents that we reported on this morning really show that the buck sort of stops with Mitt Romney. He still had all those titles. He still drew a paycheck as an executive. It's sort of hard, I think, to wash your hands entirely.
Roberta, I worked at the Financial Times for many years. I've never heard of an inactive managing director or CEO. But let's take them at their word that there are companies out there that have people who have a leave of absence for many years but still hold the title for whatever reason. My question is, what would that reason be? If you saw a company that had a leave of absence CEO for 3-4 years, why would the company want to do that? Why would the individual want to do that? What reasons do you imagine would be reasonable for that?
I don't know. It may be because people thought that Mitt Romney was a good CEO, chairman. He had a certain reputation on Wall Street, but
he was no
that
longer
makes
there.
him accountable.
Right, but say he was no longer there, right? He wasn't physically present. Why would the company or the individual still want to persist with this?
Well, but if he's the 100% owner, he decides who's going to be the CEO.
That's the thing that really didn't change, is he owns 100% of it.
He's the decider.
Yeah, there you go.
The immortal George W. Bush.
The shareholders elect the directors, and the directors pick the CEO. But if he's the 100% shareholder, he can call the shots as to who the executive officers are going to be, and obviously he chose himself.
Roberta, I want to telegraph out to the sort of practical realities here in terms of the campaign season, because it seems clear if you're running for president, what you want is a compelling narrative and not a whodunit, which is basically what is happening here to Mitt Romney's campaign. I mean, we are now talking about sort of the ins and outs of SEC filings. We have Vanity Fair stories talking about whitewashing money overseas in the Cayman Islands. This is all highly dubious. And I guess I wonder what needs to happen before the SEC says, something fishy is going on here, we're going to investigate further.
Well, these documents are for a long time ago. I don't know that the SEC would necessarily be investigating further. I mean, I think it's more a question of really what was said at the very outset here is either the statements in the SEC filings are false, which would be a very serious matter, and I don't think the Romney campaign is saying that. And I wouldn't really expect them to be saying that, because that could be a violation of federal law. Or Mitt Romney, who is running on a campaign of, well, I was a great businessman, and so I'm going to run the country as a business. And if you're someone who thinks that would be a good idea, you have to wonder is what kind of a businessman continues to have the offices of CEO, chairman, take at least $100,000 a year in salary, and maybe to Mitt Romney that's small change, but any one of my students would love the $100,000.
The filing simply says above 100. It could have been that he was taking $50 million in salary.
It could have been. It could have been. It doesn't. Well, he also was taking whatever profits the Bain Capital was making during that time.
We would find out what he was taking in salary if he would release the tax returns of those years, which he's not doing. Professor Roberta Carmel, former SEC commissioner, and Cal Borchers of the Boston Globe, thank you both very much for joining me tonight.
Thank you for inviting me.
And Alex Wagner, thank you for joining us for the first half of the show. Coming up, David Korn has broken another story about Bain outsourcing operations. Bain invested heavily in a Chinese manufacturing company that depended on U.S. outsourcing for its profits. David Korn joins us next.